On the record, please, the state of Florida versus Demon, President, defendant, his counsel, the assistant state attorneys. My understanding is we're missing a couple of our jurors, so we're not ready to proceed yet, but my office did get a call from one of our jurors, Claudia Campuzano Mena. She evidently was in the emergency room on Friday. She thinks she had food poisoning, is what I'm told, and she was discharged. Everything seemed to be all right, and then she's back in the ER now as we speak. She's going to let us know. She said something about she's getting checked out and examined now in the emergency room. She asked my secretary, can she come in the afternoon? But we don't know what her status is. And so I don't know how you want to handle it. You talk about it amongst yourselves. Let me know all the jurors are not going to still missing too. All right. So,
two in addition to her?
yes.
Okay.
Judge, can we approach the bench very briefly?
Sure.
We believe was elicited improperly, either by introduction of evidence that could not be authenticated or through the leading questions of the government or the state. And the court denied the motion on the basis that there was not sufficient prejudice, essentially, to do so. What I wanted to do was to highlight, make a motion to strike the evidence that was elicited to be accompanied by a jury instruction, essentially letting the jury know that evidence that's excluded and the evidentiary rules are in place to ensure that only properly authenticated and reliable evidence is put before them, and that's the reason for the rules. And when evidence is put before them that do not comport with the rules, it's because it has been determined under the rules to be either unreliable or insufficiently authenticated. The specific items which I was able to identify by recollection that were introduced and ought not have been in the manner that it was done include, but are not limited to, the following. And we move to strike it from the record. Any and all phone numbers that were contained in any document Holmes was responding.
You're not talking about physical evidence that's been marked, something that's marked for evidence. You're talking about her testimony.
Both.
Well, what was marked in that? Why don't we do this? Why don't you put it in writing? All right, file your motion and put it in writing. Give state a chance to digest it, look at it, and I'll take a look at it, and we can get back out of here. This just picking out certain this, she said this or that. I don't know. Typically I rule on objections as they come. So, and I thought I ruled on everything, all the objections for something that's in evidence that you're seeking me that's already been admitted, that you want to strike and have excluded from evidence. I'm more than happy to talk to you about it and more than happy to listen to your arguments. But I think I need to have something to digest. So why don't you put it in writing, give everybody a chance to look at it and do some research on it and find out what the law is. I don't know what the law is on that.
On striking inadmissible evidence?
No, the law on having something that's in evidence removed from evidence. Something the jury already saw.
One
You put
thing,
it in writing.
I understand. One thing, Your Honor, we have another court reporter now. And I think if we're gonna put it in writing, it should be complete enough, and we would need a transcript of Ms. Holmes' testimony so that we can be sure to identify all offending references.
I'm sure you can order that, and I'm
I
sure
think
that,
she's out for the week. Is she?
my understanding is that she had a calling from higher authority. Fourth DCA is what the transcripts.
I thought there was no higher.
Fourth DCA is what the transcripts, and that's what she's, my understanding she's working on, so you tell her what you need, and I'm sure she'll get it to you.
Okay.
All right, so we'll be in recess. I'm gonna make a phone call, and I'll have my Jay make a phone call, find out what the status of the juror is. All right?
Thank you,
So,
Judge.
We'll be in recess. Capozano indicated she's in the, still in the hospital. She's on an IV, and she believes that she's dehydrated. And that's just giving her fluids. She thinks, can't confirm it, that she'll get out sometime today, and she thinks that she'll be here by 1:30, but nothing's definite now, doesn't know. So I want you guys to talk it over and let me know what you think,
Yes, sir.
and I'll make a decision.
Yes, sir. Thank you, Judge.
We're in recess.
Recommendation that we like.
Stay okay with that?
I just have one witness that we might have to address a little bit because she has a custodian normal, and she also has a injury hearing. She's hearing virtually on this afternoon. So as long as we can accommodate that, save time with it.
You okay with that, Mr. Easton?
Yes.
All right, so let's do this. How about if I tell Gary, just to let the jury know that we had an issue came up. I mean, he's not going to go into any detail, but an issue came up, and we'll see them back at 1:30.
Yes, sir. No
Does that
problem.
work for everybody?
Yes.
Sure.
Thank you.
All right? Yes, sir. All right, just remember, I have one.
Can I go ask the witness on scheduling? So
Sure.
we can finish it.
1 second.
Thank you.
Yeah.
And your hearing is at 4, Your Honor, so that'll be fine.
State's good with that, defense is good with that, 1:30.
Yes, sir.
All right? Just tell them, be back at 1:30. Thank you.
Thank you.
I will be in recess. Okay. You all ready? Go. Council, I'll bring you in, is that all right? Yes, sir. All right, let's go to the jury. Thanks, Tom. Jury entered. Okay. Did you see it? Let the record reflect the further his counsel, the assistant city attorneys, and as well as ladies and gentlemen, jury. They don't, sorry for the late start, hopefully everybody's all right. We appreciate your patience, we also appreciate the fact that you're all here, and we thank you. But we're ready to begin again. When we left off last week, the state was still on its case in chief. Madam, please, your next witness.
Susan Johnson of T-Mobile.
Susan Johnson, please. Good afternoon. Are you Susan Johnson?
Yes, sir.
Welcome.
Thank you.
What I'd like to do is raise your right hand for us.
Do you solemnly swear or affirm testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Susan Johnson,
Please spell your first and last name for the court reporter.
SUSAN,
Please have a seat.
Thank you.
Ms. Johnson, that microphone in front of you will jump up or down, but not back and forth. Okay?
Thank
You
you.
ready to proceed, ma'am?
Yes, sir.
Counsel, you may.
Yeah.
Good afternoon, Ms. Johnson. How are you today?
Good, thank you.
Could you please introduce yourself to the ladies and gentlemen of the jury and tell them where you work?
Sure. My name is Susan Johnson, and I work for T-Mobile.
How long have you worked for T-Mobile?
A total of 26 years.
And what do you do for T-Mobile?
I am a manager within the emergency response unit.
Prior to working for T-Mobile, did you work for any other telecommunications companies?
Yes, I did.
And what were those?
AT&T Wireless,
And how long did you work for AT&T?
5 years.
How long in total have you worked in the telecommunications industry?
31 years.
So you indicated you were part of the manager of the emergency response.
Legal emergency response.
And what does that mean?
That means that we respond to subpoenas and other legal demands from various agencies across the United States.
And when you say a legal demand, what would you mean by that?
Subpoena or a court order, search warrant.
In terms of the records when you work with them, how often do you work with them?
Every day.
What do you do with the records?
So we're able to retrieve the information from our secure computer database and then send the response back to the agency that's requesting.
And I know this might sound silly, but what type of company is T-Mobile?
We're a wireless telephone carrier.
And is T-Mobile the parent company of any other wireless carriers?
We did acquire Sprint.
How long has T-Mobile been the parent company for Sprint?
April 1st, 2020 is when we acquired that.
In terms of the information that is kept by T-Mobile, do you keep phone call records?
Yes.
What would you call those?
Call detail records.
Do you keep information regarding the network?
Yes.
Do you keep information regarding subscribers?
Yes.
What type of information is kept in a call detail record?
So call detail reports will show incoming and outgoing phone calls or text messages made or received by the cellular telephone.
Does T-Mobile keep that information as to when data is used?
Yes.
Will a data phone call or video call show up in call detail records?
No.
Does the information show for who is being called?
Yes, it will show the transaction of the outbound or inbound phone call on the call detail records.
Does T-Mobile keep the cell phone information for the call that the outgoing non-T-Mobile subscriber?
No.
What's the purpose of collecting this information at T-Mobile?
Billing purposes.
Is there any consideration as to the health and optimization of the network?
So we keep what is known as timing advance records, which is solely for engineering purposes, so that they are able to check up on the network, yes.
When a phone call is made from a cellular device or handset, can you describe from the network perspective what happens?
Sure. So what happens is the phone reaches out to the tower with the strongest signal, which is not necessarily the closest tower. So for example, we can have a tower on top of the building, or we can have one down the street. However, the one down the street might be the stronger signal and would pick up that call. At that point, it's transferred to our switch, and our switch is what records all the information that you will see on the call detail records. At that point, it's then transferred to a landline company, and it's the landline company that actually delivers the call.
So you mentioned true call data. What is that?
So true call data is for the network. It will show where the phone is connected to when it's not in use, as long as it's turned on.
Does Sprint also have a similar type of data?
Yes,
What is per call measurement data?
correct.
Is that the same for true call, the Sprint analogy?
Correct. That's Sprint's term.
In terms of subscriber information, what types of subscriber information is kept?
So the subscriber information, we have two types. One would be a prepay, and then the other would be a monthly account.
So the prepay, what type of information could you have?
So prepay, a customer is not required to provide their information, but they could provide a name, address, and date of birth.
On the postpaid or the billed type, what type of information do you have?
So we would have the name, the address, date of birth, social security number, and we actually do a credit check on that individual.
In terms of the individual using the specific phones or handsets, can you testify to that?
No,
How many times have you testified in court before?
over 1,000 times.
Were you, as the record custodian, for T-Mobile provided legal process, and I go through them one by one, under reference tracking number for T-Mobile, 214-6318, for two phone numbers of 305-922-9533 and 954-376-9158.
Yes,
As the T-Mobile records custodian under tracking number 219-2645, where you provided records and requests and legal process for three phone numbers, 561-720-3210, 772-713-9807, and 954-376-9158.
yes,
As the records custodian for T-Mobile under T-Mobile tracking ID 208-1851, where you submitted requests for phone number 954-248-9081.
yes,
For T-Mobile tracking number 217-2715, for phone number 954-376-9158, where you provided a legal process to obtain the records for that issue.
yes,
Were you also under tracking number 205-8127, asked to provide the legal process phone number records for 772-713-9807?
yes,
Was Sprint at the time, part of T-Mobile, under the phone numbers for 772-713-2341 and 954-371-7895 under Sprint tracking number 2018-221418, provided legal process and requested to provide records.
yes,
Was Sprint under Sprint case number 2019-15821, asked to provide records with regards to phone number 225-529-5054.
yes,
Prior to coming into court today, did you have the opportunity to review the records that were provided?
yes, I did.
Are these records made at or about the time they are created by a person with knowledge?
Yes,
Are they kept in the regular course of business of Sprint and T-Mobile?
yes, they are.
Is it in the regular practice to keep such records?
Yes,
You're at this time approaching with what's been labeled as states 000 for identification purposes and previously shown to defense. Ms. Johnson, do you recognize this USB?
Yes, I do.
You recognize it.
My initials and today's date are on the USB.
And does those USB fairly and accurately represent the records that were provided by T-Mobile in response to the tracking numbers that we just discussed, as well as to Sprint and the tracking numbers and case numbers they used?
Yes.
Here at this time, the state would offer state 000 as state 63.
Any objection?
Yes, Judge. Objection? Relevance?
Sure, watch him side. Thank you. So, objection overruled, it will be admitted. What's the next number?
63.
63 no.
Permission to publish?
You name it.
I'm sorry, I didn't catch you.
63.
So I'm going to start with the Sprint records. What are we looking at in this particular file, 2018-221418-6155597?
This would be the subscriber information.
And in terms of looking at this particular one, I'm going to zoom in. What is the billing name for this?
Chris Thomas.
And going to the second one, what is the billing name on this one?
The first name is Dontavius. Last name is Withers. Withers.
At the top of this screen capture, there's a BAN number. Do you know what that means?
Yes,
What is that?
that would be the account number.
Does that correlate with the other data that's been provided?
Yes.
Going to now the same Word document file name. What are we looking at in this Sprint document?
This is also subscriber information.
So you had mentioned that billing account number, that BAN number.
Correct.
If you can touch the screen in front of you, you can write on it and it will show up on the screen for the jurors. So if you could point out where the billing account number is here. Okay. And then what is the phone number that was being used by this account, or the subject number?
772-713-2341.
And is this again for that Chris Thomas billing account?
Yes.
Okay. Scrolling down to the next billing account number. Is this the other account that we just looked at the subscriber information on for Dontavius Withers?
Yes.
And what is the phone number that's associated with this particular account?
954-371-7895.
Going on to 2019-158-210-6566861. For the phone number in question on this particular record, is that labeled right here?
Yes.
And what phone number is that?
225-529-5054.
And looking at the Microsoft Excel viewer, can you explain to the ladies and gentlemen of the jury what we're looking at here?
These are the call detail records with cell site information for Sprint.
over to the T-Mobile records. Just for demonstrative and illustrative purposes, when you are looking, this particular one called Timing Advance LTE and UMTS _ TN 772-713-9807. Then it has another underscore IMSI. What is an IMSI?
That stands for International Mobile Subscriber Identity Number, which is the number that's associated with the SIM card found in the back of the phone.
And the first, the 772-713-9807. What is that?
That would be the phone number.
Are all of these records provided by T-Mobile?
Yes.
In terms of completion codes, is that something that is reflected in these records?
Yes.
What is a completed successfully completion code?
So that means that the call went through the network successfully.
What is an abnormal completion?
An abnormal completion means the call did not go through. Perhaps the user hung up prior to the call connecting or a dropped call.
In terms of what time frame are all of these records kept in?
We keep them in UTC time, which is Coordinated Universal Time. So depending on what time of the year it is, you would have to subtract either 4 or 5 hours from the time that you see reflected in order to arrive at East Coast time.
On October 26th of 2018, how many hours did you have to subtract?
It would be -4.
The cell site locations indicate latitude and longitude of the cell site. Is that now there's also a physical address. Is the physical address always the same as the latitude and longitude?
No.
What could the physical address sometimes show?
So that's what we refer to as an administrative address. So we use that for 911 purposes. To get the exact location of the cell tower, you would take the two coordinates, the latitude and longitude, plot it into a mapping program such as Google Earth, and that would be the exact location.
So nothing further to this witness.
Counsel, is there any cross-examination?
One second, Jim.
Good afternoon.
How are you?
Good, thank you.
So the technology that you just described for identifying locations, how is that verified by T-Mobile itself?
That you would have to ask an engineer for.
So you don't know how that's done?
How it's verified?
Yeah.
As to what tower connected to? Is that what you're asking?
Yes.
So it's done with a radio frequency, is how the towers work. It's a signal.
Okay. So, but you were telling us earlier that the phone does not necessarily connect to the nearest tower.
Correct.
It connects to the tower with the strongest signal.
Correct.
So how is it that you know to approximate, how do you know how far the phone is from the actual tower?
I don't.
Is there no way to tell that?
No. Not through me.
Not through you?
Correct.
And how do you know if the tower that the phone connected to is the closest tower or the one with the stronger signal?
That would not be a question for me. You would have to ask an engineer.
How would you know whether or not a phone defaults to a stronger spectrum? If you have a tower with a strong signal and another tower with a not so strong signal, or a signal that's not as strong as the other. You with me so far?
Yes.
How would you know at what point the signal disparity is strong enough for it to default to the one that's further away as opposed to the one that's closer?
Again, that's a question for an engineer, not for me.
So you have no way of helping us understand any of this information that you just described.
Correct.
You just collect it when you're subpoenaed and you provide it.
Correct.
And you're not familiar with the technology at all.
Not the questions that you're asking, correct.
One,
Sure.
is it correct that the data location information, the purpose that you worked with Sprint and with T-Mobile at some point,
I'm a T-Mobile employee.
and you were a Sprint employee at some point?
No, sir.
You were somewhere else? No?
AT&T.
AT&T.
Correct.
The purpose that AT&T, and in this case now T-Mobile, collects this data location information is for billing.
Correct.
That's its only purpose.
And network engineers collect to optimize the network.
Okay. It's not used for identifying the locations of customers' phones beyond the purpose of just billing.
Correct.
Thank you.
Sure.
Thank you. Is there any redirect?
Yes, Your Honor. Ms. Johnson, counsel asked you, how do you know of something didn't happen? Is that a fair question?
Objection.
The same, rephrase.
With regards to these records, are they accurate?
Objection.
What's the objection?
Lack of foundation, Chief.
Why don't you stop work? Rephrase.
So, Ms. Johnson, with regards to the records, does the T-Mobile keep any record of something that doesn't happen?
No.
What is contained in the records that have been provided?
Calls and text messages that have happened.
Is this from the network's perspective?
Yes.
Nothing further, Your Honor.
Is this witness excused?
Yes, Your Honor.
Thank you. You may step down. You're excused.
Thank you, Judge.
Who is your next witness, Captain?
Jonathan Zeller.
Jonathan Zeller, please. Good afternoon.
Governor, sir.
Are you Jonathan Zeller?
I am, sir.
Welcome. You come on up here, sir. That's our witness stand. When you get there, you just think that, raise your right hand, be sworn.
Do you solemnly swear or affirm the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Jonathan Zeller, this is Z-E-L-L-E,
Spell your first name as Wilson.
Jonathan.
Thank you.
That microphone will go up or down, and I'm back up. If you're ready, you may proceed.
Good afternoon.
Can we approach?
May I go turn?
Anything else, Councilman?
No, good.
Bradley, if you're ready, you may proceed.
Okay. Detective, how are you today? Good. Where do you work?
I work with the Enhancements
How long have you worked for the Miramar Police Department?
for 23 years.
What do you do for the Miramar Police Department?
I'm a detective in the homicide unit
And how long have you been in the homicide unit?
since 2009.
Prior to going into the homicide unit, what other hats have you worn for the Miramar Police Department?
Several. One in particular is the digital forensic examiner.
Okay. What is a digital forensic examiner?
So what I do is we'll stick with the cell phones or cellular phones or devices of that nature. I do the extraction and the analysis for it.
And when you're doing an extraction, can you explain to the ladies and gentlemen of the jury what types of software or tools you use to do an extraction on a cellular telephone?
So what we use is a software and hardware from a company called Celebrate. And this is specific for conducting extractions of cellular devices.
And approximately how many different trainings have you taken in the use of Celebrate systems?
Taking a few, each of them consisted of 40 hours of class training and exercises, and obviously the exam as well.
What about you taken training with the task team of the FBI?
I have.
Have you taken, you said you also do analysis of the cellular forensics or digital forensics. What do you mean by that?
So, depending on what the case is, I will actually do the extraction and I'll also do the examination of it, so the analysis for it, and go through it and look for items that potentially could be considered evidence.
And in terms of to do the analysis part, what information do you need?
I need to know the case.
In this case that we're here on today, Miramar Police Department Investigation 18-10-06269, were you the lead detective?
I was not
What was your role in this case?
doing the analysis or the extraction of the device.
Did you do any analysis of the device?
I did not.
In terms of the extraction of the device, so you provided an iPhone with a phone number attached to it of 772-713-9807.
Yes, yes.
Prior to coming to court today, did you have the opportunity to review the digital copy of that extraction?
I did.
Showing defense counsel what's been marked as state triple P for identification purposes, showing the witness. Detective Zeller, do you recognize this thumb drive?
I did.
How do you recognize it?
My initials and my ID number on the jump drive.
What is that thumb drive contain?
This is the generated report the generated report of the cellular device that was extracted.
And is that in the same or substantially the same condition as when you performed that extraction?
Yes.
Here at this time, the state was requesting a state triple E in a state 64.
Yes, sir. Maybe.
Sure.
So Detective Zeller, can you explain to the ladies and gentlemen of the jury what an extraction does?
So the extraction is done in order to obtain whatever is on that phone and to put it in a legible or readable report that's easy for someone to look at. And some of the things that you get also by doing that, you may get items that have been deleted, so on and so forth. And that's why we do those types of extractions.
Nothing further from this witness, Your Honor?
Any cross-examination?
Yes, just briefly.
How are you, sir?
Good news, sir.
You said you did a phone dump here of a particular unit that the state purchased,
That's correct.
and you have not analyzed it.
No,
You don't know if there's any relevant evidence on it at all.
that's correct.
Okay. And you don't know who it belongs to, do you?
I do know who it belongs to. Obviously, I'm in the office. I know who it belongs to, but as far as the contents of it, I don't know.
You don't know who uses it.
I do not.
You don't know who it's registered to.
I do not.
Okay. 1 second. And as to any contents of that phone, you don't know if they're texts, who authored them?
Once again, I don't know the contents of it.
Okay. Your Honor, we'd like to come sidebar. Is an app on a phone that purports to account for the number of steps that someone takes. In addition to these cases, I have several articles. There have been lawsuits about the accuracy of the data that is compiled by this type of app, because what it's doing is it's assessing reverberations. So, for example, one of the experts we spoke to indicated that his wife plays the piano at church, and every time she goes to church and comes back, she's taking 20,000 steps because she's doing like that. So the fact is that whether or not this information is reliable is yet to be determined. Whether or not the technology has advanced to the point of being reliable is yet to be determined. But this court cannot admit it until the state first meets its burden of establishing the reliability of the data that is compiled or purportedly developed as a result of the technology. Because we don't know if that technology is accurate. Whether it is or not, I'm not taking a position at this time. I know I've read a lot of articles that indicate that it's not. However, the state has the burden as an authentication hurdle to have a foundation establish that that technology is a reliable one, because she is going to now, and she's introducing the matter for the truth, told the jury in opening, Mr. Demons, who she believes had the phone but has no proof of that to begin with, walks 70 steps. Says who? Says an app. What app? The one in his phone. Is it reliable? We don't know. Why? Because she has not established the reliability of the technology as a predicate to the admission of data. So that is our number one foundation argument.
Case that you want me to read?
Yes, sir.
I have to take a look at it.
Thank you.
Yes, ma'am.
Here, I first start with citing back to State versus Maximus, which is a 1967 case, which was the earliest time in which I could find a pedometer being mentioned. And at that point, it's important to note this is a well-established technology that's been in use for hundreds of years, initially done by train conductors to measure out distances. It's also allowed under the Florida statutes and used to be used to measure out distances for determination of 1,000 feet from a place of worship, a school, or anything else, for measuring distances for enhancement on drug penalties. So I'd start by handing that one to Your Honor. Then I also have State v. Birch, which is a Wisconsin case in which similar information was admissible and used in a homicide case. Then also in the issue of cell phone dumps, and that's at 398 Wisconsin 2nd 1. And then even more recently, this was a federal case, United States versus Rigo, R-I-E-G-O. I just have a Westlaw site because it's 2022, it is not yet. This is 2022 Westlaw 175467114. Again, those discuss all of the location information and the activity and Apple Health data that was admitted in those cases. And I'll be happy to email copies of those to defense counsel now.
Thank you. All right, we're in recess. I'll read them.
Your Honor, may I also just direct your attention to a few articles, one of which indicates the highlight here. The reliability of the registered distances, however, depends on a number of factors, including walking speed and walking style of the subject, and can deviate up to 30 to 40% from the true value. That's one of the several articles here. And what I will do is I will compile articles and send them all back for your review while you're considering the issue if you don't mind.
Sure. The state would also submit in terms of law review articles, including a 2016 wearable devices as admissible evidence. Technology is killing our opportunity to lie. The 2019, the iPhone health app from a forensic perspective can steps and distances registered during walking and running being used as physical evidence. And I would direct our attention to the Supreme Court of Alabama. That was Jeffrey West. The individual in that case was convicted as well based on some of the Fitbit data.
May I just ask if the state is making the representation that all the cases she's citing to do not require that a witness establish the reliability of the technology? It's just put in?
It has been admitted, and I have some of those, and everything that I'm giving to this honor is copied to you as well.
Okay.
Thank you. We're in recess.
Thank you, Judge. The expert, not even the method. And so we raised the Dauber issue. We gave notice of an expert. The state took issue with it, raised the Dauber objection to it at that time. This is not a situation where the state presents us an expert. And we can't anticipate that the state is going to try to admit evidence before they admit it without the necessary predicate. And those cases actually speak to the objection being made at the time that it is sought to be introduced. As a matter of fact, some of those cases rejected the appeal because even though the predicate wasn't made, the objection wasn't made at the time the evidence was sought to be introduced. The state sought to introduce evidence without laying a foundation. Our objection is objection foundation. We're not making a Dauber objection to an expert who's testifying. He doesn't purport to be an expert. This is not a Dauber situation, Judge. This is a lack of foundation situation. And the fact that that foundation needs to be presented by somebody with expertise and knowledge doesn't make it a Dauber question. It's a foundation question. And before the state, I think those cases are clear. If the state is planning to put evidence in that relies upon the technology, they first have to establish the reliability of that technology. And that's the basis of our objection with respect to this step down. We've also made a relevancy objection to the fact that there is a wholesale dump of information coming in through a witness who said, I haven't even looked at it. How do we know that the information in there is relevant? How do we know that the information that has been introduced is not more prejudicial than probative, even if relevant on a 404B? How do we know that it's not doesn't contain 404B evidence that's inadmissible? The state has to establish the relevance of the information they seek to put in. They can't just put in everything from a phone and pick through what they think, and then the jury has in its possession a host of majority information that's not relevant to the proceeding, which is prejudicial. So that is the other basis for our objection. Also, a lot of the information contained there is hearsay. They said, well, it's his phone, so there's no hearsay objection. There are texts between people. There's also evidence that we have that establishes that that phone was being used. The phone comes up as the name Sack Chaser Howard. Sack Chaser is the nickname of one of the decedents. That phone is used interchangeably so much that when you dial with it, it comes up with one of the decedents' name as the identifier. It's in the name of Jamie King, not Jamell Demons. It was retrieved from Jameson Francois, not Jamell Demons. So it's neither in his name, it wasn't retrieved from him, and it comes up with an ID. It was being used after the defendant was arrested. We have information here that indicates that definitively. It shows the phone being used to call. It shows the same step data from that very unit after he is incarcerated. So it's obvious that it's being used by several other people. So we can't even say that it's his phone and the information there is therefore all relevance, all information on it is non-hearsay because it's statements of the defendant. Not only is it being used by others to text, to call, being carried by others, it's in somebody else's name, retrieved from someone else, and this witness has not analyzed a single letter, all the information that they can put in. So there is a ton of irrelevant evidence that is being introduced, and a lot of it is going to be prejudicial, 404B and 403 evidence, and that's why we objected before. I didn't wait until after, because one of the points that the court made is you already let it in. We objected before, Judge, and you told us, overruled, let it in. It's still a problem right now, and we're trying to stem the damage before it goes too far. And we think that the issue has to be addressed before this information is used and it goes forward, both on the foundation issue, on the technology issue, authentication issue, relevancy issue, 403, 404B issue.
Thank you. The relevancy issue is relatively low, counsel. My understanding, where's the phone located at, counsel?
The phone itself,
Yeah.
that will be introduced through the
No, where was the phone located?
The phone was located, it was taken from the defendant's manager on February of 2019. The defendant was providing the passcode and information via jail calls to his manager to use it on that. And the phone also authenticates itself in terms of every single photo that is on that, whether it be a selfie, a screenshot of a FaceTime conversation, or anything of that, goes back to this defendant.
Then they have to establish it before they put it in, not after the fact, on this notion that they possess information that makes it relevant. If they do, present it, and then it's relevant at that time. We have, Your Honor, indications of this cell phone and this Instagram account that the state has introduced. The Instagram account is being used to post pictures days after his arrest, up to and including pictures of this very trial last week. This Instagram account is being used and accessible to a number of people. This notion that, oh, it's his account, he's an artist. It's a public account that several people have access to.
I'm sure you're going to be able to ask those type of questions, counsel. My thought is this, counsel. It's not fair to basically give me an inch worth of things to read, cases to read, articles to read, saying it's how it's not, the methodology is, and it's basically the Albert issue on it. It's not clear, it's not been established, all those types of things. That should have been done pre-trial. I haven't seen what's on the account. I don't disagree with that. Counsel's telling me it's relevant because of X, Y, and Z there. You're saying it's not, but I don't know what is the 403 analysis, what's more prejudicial and probative. I haven't seen anything about that. I don't know what it is. I haven't seen it, you haven't made me aware of it, you're just saying it's something more prejudicial than probative. If it is, I'm more than happy to go through one at a time with you and find out. But as far as who used the phone, what was it being done, counsel's saying it's relevant to establish his phone. So I've made my ruling, you've made your objection, so everybody knows where they stand on it. All right, so it's admitted.
Okay.
All right.
Thank you.
All right, bring the jury back in.
Process. Are you finished with your cross? Or are you going to be all that? Yes.
I don't think he has any relevant information. He said it.
So you're finished?
Bring the jury.
Let me ask a few.
Carrie, entering. Ladies and gentlemen, thank you. Dr. Delay, please be seated. Let the record once again reflect the expression of the defendant, his counsel, the assistant state attorney. Ladies and gentlemen, jury, all witness will need to stand. Do you have questions, counsel?
Yes, I have a few more, Your Honor. Thank you. You did, sir, 2 data dumps from the device in question. But it's 2 or 1? You did 2 of them, did you not?
I did on this device, I did one extraction.
You only did it once?
If I recall,
Did you have the data verified by any third party for completeness of the download?
no.
And you made that decision, was it your decision whether or not to do that kind of verification?
Yes.
Okay, and you elected not to?
Correct, I did nothing.
Did you have an engineer review any of the data that you retrieved?
No.
And have you validated that the Cellbrite extracts in the data that you did were in fact complete?
The extraction is the extraction, and that's what I got out of it. That's what the machine gave me, yes.
Okay, and how did you verify that the machine gave you a complete download?
I understand when you say a complete download.
You said you don't understand what I mean?
No, we can elaborate on that.
How did you verify that the machine, the Cellbrite software that you used, downloaded the contents of the phone in its entirety? How did you go about verifying?
That is not something that I can verify. That is whatever the data that comes from that phone and appears on the software. That's what I have. That's what I can do.
Okay, so you can't verify.
I cannot.
Is there a process of maybe testing? Is there another, first of all, software that you can use to download the information?
Sure, there is other software.
And you only use the Cellbrite?
Correct.
And if you use another software and compare the download, that would be one way for you to test it, whether or not the download was complete, right?
In theory, I guess so, yes.
In actuality.
All right, I'll say it.
Okay. So when you say there's no way to do it, it is what it is, what you're saying is there is a way to do it, and you didn't do it.
If that's what you want to call it, but it's not true. That's not correct.
Oh, so you did test it on another software?
No, I did not. But this is the only software that I had available to me.
Okay. So it's not that you had another software available to you that could help to verify the completeness and accuracy of your results. It's that you can do it, but you didn't have that software available to you.
Well, correct. I did not do it, no.
Do you know anything about the testing of the technology of Cellbrite as to its efficiency and operability?
No, I don't. I'm not an engineer for that.
So you, pardon me?
I'm not an engineer for that.
Okay, so it would take an engineer to do that?
Or somebody from that company, not me.
Okay, so it's like any kind of software. If you have the software and it doesn't work in totality or it doesn't work completely, you're stuck with the answer.
I'm not understanding what you're trying to get at, but if you rephrase it one more time, I appreciate that.
If that Cellbrite did not give you a complete and accurate download, you would have no way of knowing it.
That is correct.
Okay. Because you didn't have comparable software or similar software to test the results against.
Correct.
Okay, so you're just trusting in the faith. You're just having faith that it's Cellbrite.
Sustained.
You are relying upon the accuracy and completeness of the Cellbrite technology, right?
That's correct.
Even though you don't know anything about whether or not it works properly.
Correct.
Okay. Have you ever done a data dump from a phone more than once? Any phone?
Yes.
On Cellbrite?
Yes.
And was it a phone that left your possession and then you regained possession of it?
When you're saying left my possession, I'm sorry.
In other words, it left the custody strikeout. In the instances when you had downloaded information from a phone on using Cellbrite more than once, I presume you did it for a reason.
So one of the reasons why I probably would do it is maybe a software update from Cellbrite.
Okay, that's one of the reasons. What else? What are the other reasons you might do it?
That's the reason that I would use it.
Okay. Can I have one more, Your Honor?
Yes, sir.
So it is your testimony, sir, that you didn't do an extraction from this phone in June?
What year is this?
And then another at a later date?
I don't
Or
recall.
at an earlier date in April?
I don't recall.
Well, you have any information there before you? Any of your reports that would indicate that?
I have one that was completed on February 28th.
February 28th. Okay.
2019, I think it was.
Okay. Nothing further. Thank you.
Counsel, is there a redirect?
Briefly, Your Honor. Detective Zeller, counsel asked you whether or not Cellbrite is accurate.
Correct.
In your training and experience, can you speak on that particular subject?
Objection?
What's the objection?
This witness has already testified that he can't speak.
Sustained.
So Detective Zeller, in terms of you've used Cellbrite numerous times,
That's correct.
approximately how many?
Hundreds.
Have you found any instances in which Cellbrite added data to a forensic download or download that wasn't on the phone itself?
I'm sorry.
Objection?
What's the objection?
You would have no way of knowing that.
Overruled.
Can you answer one more time?
Have you ever had an instance in which Cellbrite has added data to the forensic extraction or data dump that was not on the phone itself?
That was not on the phone? Not that I'm aware of.
In terms of the way to physically review, how would you do that on a cell phone in comparison to Cellbrite extraction?
Well, there's a couple things I could do. I could look at the different artifacts that are extracted, meaning, so I would look maybe at a particular phone call was made at a certain time and date, or a certain picture that was there at a certain time and date, or a video, or so on and so forth, whatever that's there. That's one way to do it, yes.
So I want to make sure I'm clear. Are you saying you would look at outside evidence from the phone and see if it agrees?
Correct, yes.
In terms of the information and the data that's put out there, what is the purpose of taking it off the phone?
Well, you also don't want to you don't want to use the original, and just pretty much making a copy of the phone so that you don't ruin anything, delete anything, compromise the device, or anything of that nature. So you work off that copy.
In terms of when the phone is brought to you, are there steps that are taken to make sure that there's no outside or internet or network access to the phone?
Yeah, so usually the phones are put in what's called airplane mode, where you disable all cellular connections.
And in terms of the type of extraction that was done in this case, what type of extraction was that?
This is called an advanced logical extraction. So,
What does that mean?
so there's different forms of extraction. The advanced logical pretty much gets, for the most part, when I use the word everything on there, when I say everything, the context, their pictures, their videos, the communications, any sort of communications that are on there, deleted items, specifically deleted items.
Okay. And in terms of to get the advanced logical extraction, what information do you need as an examiner?
Meaning, I'm
Do you
sorry.
need the passcode to the phone?
Yes, you do need the password, correct? Yes.
Nothing further.
This witness excused.
Yes, sir.
Thank you. You may step down. You're excused. Thank you. For your next witness, please.
Brendan Collins.
Thank you, Brendan Collins.
Yes, sir.
Welcome. This is our witness stand. Can you come here, please? When you get there, just remain standing for a bit. Raise your right hand, be sworn.
You solemnly swear or affirm that testimony you should give in this case shall be the truth, the whole truth, and nothing but the truth.
Yes, I do.
And state your full legal name for the record.
Brendan Collins.
Please tell your first and last name for the court report.
My first name is spelled Brendan. My last name is spelled Collis.
Thank you, sir.
Thank you. Please be seated. Collins, that microphone in front of you, adjust up or down. It doesn't need back.
Thanks, sir.
Great.
Yes, sir.
Counsel, you may.
You. Good afternoon, Mr. Collins. How are you?
Good afternoon, I'm doing well.
Where are you employed?
I'm an FBI agent. So I'm employed by the Federal Bureau of Investigation, and my full job title is supervisory special agent.
And how long have you held that position?
This current position, about 18 months. I've been employed by the FBI for since 2012.
And as far as education, what types of degrees do you hold?
I have a bachelor's.
And is it in a specific area?
I was a history major in college.
Were you employed anywhere else prior to working for the FBI?
By the Army.
And how long were you employed by the Army?
About 6.5 years. I had a couple of different jobs.
Going back to where you're working now, the Federal Bureau of Investigation, what are your responsibilities as an FBI agent?
Well, agents do all sorts of different things. Generally, agents are all investigators, and in the FBI, we investigate a myriad of crimes from violent crimes, economic crimes. We also have national security mandates. Me specifically right now, I'm the supervisor of a squad that focuses on transnational organized crime.
So do you also have an ancillary assignment?
Not right now, I used to.
Would you explain to the ladies and gentlemen of the jury what is the task team for the FBI?
So CAST, for the Cellular Analysis Survey Team, is a group of specially trained and equipped agents and task force officers who do cellular analysis or mobile device location analysis.
And so when you say that, what types of records are you working with?
Usually records from phone companies or other service providers.
Okay. Can you explain to the ladies and gentlemen of the jury what is historical cell site analysis?
Sure. So when someone uses a phone or a mobile device to do something, to make a call, to send or receive a text, to check a sports score, or check their email, post something on social media, that's to connect to the cellular network or through the internet. When you connect through the cellular network, there's a record that's generated by your phones, by the phone company. So you have T-Mobile gives you service to your cell phone. When you make a call, you'll see records on the T-Mobile sheets about that call. Historic cell site analysis is using those records to answer questions,
So what's the purpose of historical cell site analysis?
to help with investigations.
And what are the main components of a historical cell site analysis?
Well, if you're being asked to do like a location analysis, in other words, to the case involves trying to determine where a particular device was at a certain point in time, you really have three things that you need. First, you need the records for that particular device. That will say that one of the initial records, a call detail record, for instance, will sort of look like a billing statement that you might get from a phone company. Will say, this date, time, this phone number, place this call to this other number, etc. Except it will also have additional information. It will say a cell tower that the phone connected to when it made that call. So you need that record about the device. You also need a record of tower locations that says, okay, the tower the phone connected to is located at this particular point on the earth. Put those two things together into some sort of mapping software and plot it, and then it will give you a general area where the device was at the time that it connected to that tower.
So you said device. Can you testify a specific person was in a specific area?
No.
Why not?
The records I have are just about devices.
Okay. So there are limitations to your testimony.
Yeah, absolutely. Yeah, I'm talking about devices, not people.
Have you received any specialized training to become an agent that does CAS as
Yes.
well? What is that?
To be CAS certified is pretty extensive. There's several stages to the certification process is broken into. The first, so I started my initial training in 2017. The first basic training, that's the CAS basic course. That's a 2 or 3 day course where agents and officers from our local, state, or other federal agencies are exposed to what cellular analysis is and how to do it at the basic level.
Do you use the CAS work in your day-to-day cases? Before you became a supervisor?
Yes.
And so is this a required assignment to go to the CAS team?
No, on the, but there's a lot more training than just that 2 day thing. Is that okay?
Oh, well, let's start with, to do that first 2 day training.
Yeah, so the first.
Is that mandatory?
Yes. Yeah.
To go on past that, is that something you have to apply for?
Yes. Yeah.
Okay, and to explain after that first initial training, what happens? What's the next level of training?
So the next course is called the advanced course, and it's a week-long course, and that's just a more in-depth dive into each of the networks. So specifically, what are the uniquenesses of, say, Verizon or T-Mobile, AT&T, Sprint when it was a standalone provider? What do their records look like? What are the uniquenesses there? Where their networks designed, etc. After the advanced course, then we have a sort of test that's like a week long. When I went through, it was a mix of part in the classroom and part in the field, where it's all scenario based. So you, for instance, you'd be like a kid in a scenario, like, hey, this child was abducted. Your job is the asset going through to try and use the records to develop a search location. Say, I think that we need to go here to try and recover the child. The portion in the classroom, the portion in the real world where they have test runs set up at different locations, and you validate the results right there. So you either find the person or you wouldn't, and at the end you either pass or fail. So I passed, and I was allowed to continue to the certification course, which is a 4-week course. The first 2 weeks are very academic. We have a week that's basically a semester's worth of material, and that's the week. It's put on by professors from the Florida Institute of Technology. We bring in representatives from all the major cell phone providers in the U.S., both their law enforcement relations and records custodians personnel. We talk about These are the types of records that we keep on a specific record, that we have a specific company. We also bring in personnel from the network engineers, so the people who build the network, who design it. We go to infrastructure, so for instance, network operations center, where they oversee the management of the whole the network across the country, et cetera. And then at the end of that, there's a test, and you either pass, are certified, or you don't.
Okay, so Special Agent Collins, are you certified in CAST analysis?
Yes.
How long have you held that certification for?
I got certified in September of 2018.
Is there continuing education or recertification that's required?
Yes. So to keep your CAS certification, every year you have to attend a recertification course.
Okay. Is all of the training specifically from the FDF?
No.
What other agencies and I guess companies do the training for you?
Yes, we have partnerships, or not partnerships, but we'll bring in educators from a lot of different companies. So obviously, the different telecommunications companies are critical. So have them come to the recertification conference every year. Had a range of other people, at Apple, Qualcomm, Oracle, people in the field of GPS, cellular engineering, vehicles for vehicle telematics. Anybody that's sort of involved in that ecosystem.
Okay, so you've mentioned Apple, Qualcomm. What are those?
Those are different manufacturers.
Is there also specific as to cellular technology and how it works, training on that?
Or what?
In terms of being a CAST certification?
After recertification?
Yes.
Yes.
Okay. How long have you been specializing in call detail record analysis?
So call detail record analysis is really like the bread and butter of what CAS does. So since I started the training process in 2017, that's when I first really got exposed to working call detail records or CDRs.
Okay, and approximately how many times have you done this type of analysis?
I've done more than 130 cases and that have included more than approximately 300 sets of records.
When you say a set of records,
Yeah.
what does that mean?
The call detail record, an engineering report, some sort of data report, some sort of report from a phone company about a particular device.
And in terms of the types of cases that you've worked, what have they been?
Again, violent crimes like homicides or shootings, white-collar crimes, and then public corruption, crimes against children, terrorism.
Have you worked cases where you've been called upon to determine the location of a cell phone?
Yes.
How many?
And for the 130 so cases that I've helped with,
Yeah.
the vast majority of those have to do with location, historical location of the phone.
Have you had the opportunity to validate your historical call data reconstructions, or that you do?
Yes.
And how do you do that?
Well, as we mentioned sort of during I was talking about the crane up, if it's a situation, a case where we're trying to find someone who we believe is in possession of a device, you do an analysis and you say, I think we need to go to this house, and we go there and the person and the phone are there, that's validation. If we have a case where we have some sort of other evidence that corroborates it, like a crimes against children case, and there's metadata on media that was produced at a specific location, and cell site that said, okay, we know this film or something was produced here, and here's what the cell site looks like, and that corroborates it.
So when you say metadata, can you explain what that is?
Yeah, that's outside of what I do with CAS, but that would be something that would be in a media file, perhaps, that somebody else would extract the file from using a physical extraction device or a computer or some other device. Sometimes there's metadata embedded within the image or the video or whatever that will tell you different things, such as when the picture or movie was produced, where it may have been produced, or the picture may have been taken, etc.
Yeah, just a matter of offer Special Agent Collins as an expert in the area of historical cell site and cellular technology and offer for water.
Hey, you want to come side by side?
report that was done by Judge Siegel. This was signed on April 4th of 2023.
And you intend to seek to admit durable.
Yes. And that's what that,
Admit durable.
yes, and that's what that,
Should we just object now that it's certain admissible?
I don't know what you're speaking of.
I don't think we admitting for the court case that we would.
Excuse me, I only want to hear from one. Whose witness is this going to be? All right, so you make the objection. So this is an order on the admissibility of expert witness testimony by the Federal Bureau of Investigation, Special Agent Brendan Collins. Let me read it. Order to judge. Here, the defendant stipulated to the admissibility at trial of the expert testimony of Special Agent Brendan Collins in the area of cellular phone forensics. This stipulation includes Special Agent Collins' testimony regarding the cellular analysis survey team cast report, and based upon the defendant's stipulation to the order and judge of Special Agent Collins' expert testimony in the area of cellular phone forensics and on the cast report is admissible at trial. What's the issue?
So I believe counsel is trying to state that we are going to object to the admissibility of the cast report. We have stipulated to his testimony after deposing him. And then I will also bring to the record, she's trying to bring in 3 different cast reports when we had deposed Agent Collins. We only had deposed him as to 1 cast report. We had extensive conversations about whether the state would be bringing in the additional cast reports. We had agreed at that time, if they were going to bring in those reports, she would let us know and we could depose him again. That never happened. We were always told it would be the 1 report of the 2 phone numbers. And which we are objecting to the admissibility of those reports based on hearsay. Also, they are misleading, and also the information in those reports have not been properly validated by an engineer.
Okay, so as of April 4th, 2022, what report was in existence as far as Special Agent Collins?
so the first one that was with regards to Anthony Williams' cell phone, as well as Mr. Demon's, cell phone. That one was
What
done.
other reports are out there?
The other ones were generated in May of 2022 and immediately turned over to defense counsel, and I have a very different recollection of that. This was listed at the same time as Mr. Zeller that we just had, so there was never any additional request to depose this witness. But so Agent Collins has been available for the last however long they so chose to do so.
And Judge, I would just for the record make an objection to her characterizing that particular phone that is actually registered to Jamie King as Mr. I don't believe that's valid.
Thank you. So, what is the report?
Judge, I'm sorry, I didn't hear what you said.
I asked for the report. I need to know what the report says. I'm not familiar with it.
So they're all substantially similar. They use different cell phones at different times. That one is the one of Mr. Demons and Mr. Williams, explaining how the cellular.
Objection.
Explaining how.
I don't understand. I'm asking for what the report is. I want to see it, and you say objection. Again, what's your objection?
My objection is to the characterization of that it's Mr. Dillon's phone and Mr. Williams' phone, actually.
You have another copy.
So we know that it's Liberty Inn. About, copy it.
Thank you.
So what is Agent Collins do?
Agent Collins would testify as to how he does the analysis, how he generates those planning advanced bands, and what it means as to the location of the cellular devices based on the records. So it's all done as a product of the accuracy of the records and the fact that the cell phone communicates in a consistent way based on the laws of physics with a cell phone tower.
See, in here, it talks about the phone 772-713-9807. T-Mobile says Jamell Demons. This goes below 954-248-9081. T-Mobile Anthony Williams. And it has the date of the report being May 12, 2022.
Yes, sir.
So this report date is after the order date.
It is. That is the second. It's the same one. It was all done at the same time. I believe, if I'm not mistaken, there was a typo that had to be finished on the spelling of the defendant's name, which is why it was generated at a second time on that point.
I responded.
You responded to which one?
I would just say just to go back that it has Mr. Evans' name on it, Mr. Williams' name, that needs to be specific, along with the other three reports, which were actually filed after the code. So it is my recollection that we were told in court that it would not be used. There was a question if James and Francois CAS report would be used. She didn't give us a definitive answer. We finally rested on the fact that she was not going to be using Mr. Francois' phone. So it is a little bit of surprise that is now being introduced at trial. And the other one, I believe, with Withers, we never ever discussed it.
Hold on. Hold on.
Yeah.
I don't fully understand this order dated April 22nd. It says, order to judge Special Agent Collins' expert testimony in the area of cellular phone forensics and on the CAS report. So he's going to testify. I wouldn't normally admit a CAS report. I don't see why here. I don't see this specifically saying it's admissible. I see it's saying Special Agent Collins' expert testimony in the area of the cellular phone forensics and on the CAS reports. So he can testify. He's here. You can ask him questions that you want. but I don't believe I'd be letting this into evidence. It's just, who's here. His testimony is his testimony.
And so, with regards to that, the necessity of the maps is that especially Agent Collins is going to testify in terms of latitude, longitude, and distances on that. Without a map and using that for the jurors to be able to understand where this is placed on the actual map, that's going in a vacuum.
You can show it as a demonstrative aid if that's going to help him illustrate his testimony. I don't have an issue with that. That's a different question for me. Typically, we don't just admit an expert report. The expert here is going to testify.
Yes, sir.
And it's not clear for me from this order that that's what Judge Siegel anticipated, that the report was coming in. I don't have any issue regarding this testimony. They're not even, the defense indicated they're not even going to hire him regarding his qualifications. So, he's able to testify. But as far as the report coming in, I don't read your order that way, respectfully.
Understood. So, Your Honor, then if I can show the admissibility of the maps with that on there, then you would evaluate them as their offered individual.
I don't have an issue. I mean, he's able to identify them and talk to them. That's a different issue. You're wanting to admit the whole report in, is the way I understand it, as substantive evidence. And typically, that's not the way it's done. I mean, the testimony is the testimony of the witness. Not the report. It's cumulative, it's duplicative, or whatever he's going to testify to. I don't see, the order talks about a date in April. This report was given after that date. I don't know if this is what the judge intended. You said there were some amendments. I don't know what the amendments are. I don't know if they were approved by the defense. They're saying they're objecting to it. Typically, that's just not done the way it's being done for the main document.
So, Your Honor, there are a high number of cases on that specific issue, which I'm happy to provide the court.
What specific issue? About a report coming in?
About the maps and the mapping being admissible. So that would be...
I'm not concerned about the mapping. I'm concerned about the report per se.
Well, I just want to make sure we're clear on what specifically. So some of them, the specific items are demonstrative on that. So for example, and I can put it up so everybody can see so it's clear. So Special Agent Collins, I would anticipate to testify that, for example, there is cell power usage and how that would be displayed on that. So that wouldn't be confused with cell site usage. So that's because there could be the possibility that a juror would think, well, this is showing that the phone is somewhere in this purple area, which would not be correct, as opposed to, for example, a timing advanced illustration, which in this case, the witnesses can testify that the phone is somewhere in this band based on, and then as well as, so in terms of the way the mapping is then done, to make it clear and understand that these red dots are not the specific locations, but rather the towers that are used. I think it's important for the jurors to understand that and have the first part of that analysis there so that there can't be any sort of improper recall by the jurors on that. So then as to the locations on those, then this would be one of the timing advance. So if they don't have the other first part,
So that is renew again.
Excuse me, counsel. I don't think she's done.
Okay, sorry, Judge.
so it's more so the fact that the timing advance data and the way it is done, I don't want there to be any confusion to the jurors to saying that this is overstating the evidence. So if I just put in these particular items without the full explanation, because I don't think it is appropriate to do so without the jurors understanding the limitations of the testimony and what the different maps show. So that would be the specific parts the state would be seeking to introduce, because the locations of the towers are important to how the math is done.
My understanding is the defense is objecting to that exhibit, is that correct?
Yes, Judge.
And does that include the maps?
That does include the maps, Judge.
You're objecting to it, so I guess you, in some way, it has to come out how it was done. And you can talk to the witness and see if he can, authenticate it. Originally, I was thinking that you were using it as demonstrative, and I would ask him if that helps illustrate his testimony or not. But if you're saying you're not concerned with that, and you want to admit them into evidence, so the objection is, what's the objection?
That it's irrelevant. I would also object to the fact that
It's not relevant?
it is not relevant. It's also referring to Mr. Demond's phone. Nobody's established that number was his. It's referring to Mr. Williams' phone. We've got no testimony that establishes that it's Mr. Williams' phone. If we were to go to the other two reports, I don't know how the court's ruling on them. Again, she's records the phone numbers, assigning them to people. We have had no testimony or evidence before the court that those actual phone numbers belong to those individuals.
Thank you. So I haven't heard any phone numbers being assigned to any individuals.
If I may, Your Honor,
Sure.
that is why the state introduced the phone slip that has been brought in to the defendant's fingerprint, that he endorsed that as his telephone number, and as such, the state can now argue that. As to all of the other individuals that are coming in from the phone records themselves, for example, Dungidius Withers and Chris Thomas, that I went through with the Sprint records custodian.
So let me start. What is the phone number that's on that corner sheet that you're saying is Mr. Demons?
772-713-9807. And that's why we had the fingerprint analysis done, and they came in and identified that as the fingerprint of the defendant.
Thank you. And what's the next phone number?
The next two phone numbers that are the easiest ones to go through, Your Honor, are the phone numbers of Christopher Thomas, 772-713-2341. And if Your Honor recalls,
13341. Should be another number.
772-713-2341. And I can bring up here for Your Honor the specific information on Mr. Thomas's phone that was brought in earlier through the Sprint records custodian. And there's the phone number at the top of the screen, 772-713-2341. Billing address for Chris Thomas.
All right.
Going down in the same records, because they were produced at the same time. In addition, the email address with it is Chris Thomas 86. Again, consistent with Christopher Thomas. The next phone number that is on this particular is 954-371-7895. And that is belonging to an individual by the name of Dungidius Withers.
Are there any other phone numbers this witness is going to be testifying with?
Yes, Your Honor. He would also be testifying on the T-Mobile records to the individual by the name of Jameson Francois, and to go to the subscriber information for Mr. Francois's phone. This is related to Miss Adria Scott. There's been testimony that Adria, or AA, is the wife of Jameson Francois. In addition, that phone number for Mr. Francois, 954-376-9158, is consistently in the phone download of Mr. Demons and is listed as track And there are plenty of photographs and things of that nature that would show and illustrate that Mr. Jameson Francois, also known as Trap, is the owner of that phone number.
But it's actually in his wife's name.
Correct. And if you, the rest of the subscriber information also says it is a family plan with multiple lines. Rate plan, family, unlimited, 2 lines include them.
On the subscriber information for the first phone that you're suggesting is Mr. Demons, what does that subscriber information look like?
That comes back to his mother, Jamie King.
Let's go back now. What's on I don't know what the exhibit number was. Did you print out anything on these phones? I think there was a printout. They objected to it.
There's multiple printouts on the phone, not all of which have been entered into evidence at this point in time.
Well, what's in evidence so far?
I can pull that up. Take a moment. This is in state 64.
This is the extraction.
That's correct. For example, 954-346. Three seven six 9158. There are 1,129 messages between the phone owner, Mr. Demons, and other individuals in which Mr. Francois is a participant in those conversations.
So again, you indicated this is Mr. Demon's phone. You just told me the subscriber information reflects that it's his mother's phone.
This is the plan is paid for by his mother. His mother's phone is in here. She is listed under Brazy, B-R-A-Z-Y, lady,
and that is 772-501-6942, which is listed as an additional number subscriber on the phone for Mr. and the phone record T-Mobile for Mr. Didens.
Judge, I just want to point out, she's saying that these are messages between Mr. Jamell and various people. The cell rate actually tells you, like she stated, like it's going to track, but it's coming from Young Sat Chaser Power, and he's registering as the owner of the 9807 phone, which in these reports keep going back to Mr. Emmons, but in the cell rate is showing Young Sat Chaser Power.
And so in further showing as to who owns the phone, we can look at all of the videos and images of Mr. Didens, of which there are over 1,000 videos on the phone showing he is the user and owner of this particular device.
Judge, again, I have seen that shows that he's the user and owner. It shows that whoever had possession of his phone took videos of Mr. Jamell. They're not selfies. These are actually pictures that appears to be taken by another party.
Well, these are all videos, actually. If you want to go to the selfies, then go to the 10,963 images to show some of those.
I don't know how she's determining your selfies, Judge, that testimony section.
So, for example, in this particular image, it's a screenshot of a FaceTime conversation in which the large image is going to be the person who's on the other line. The local device is going to be the tiny picture up at the top, which is of Mr. Didens. That's just one of many, many examples.
Can you go back to the main subscriber information page?
In terms of this one.
So where does it show who the subscribers are?
This is from the device itself, right? This is an abstraction from Celebrate of that phone in terms of information as the user accounts that are on this particular phone. You have YNW Melly booking at gmail.com. You have YNW Melly a Twitter account. You have YNW Melly an Instagram account. You have Melly.Montana, the Snapchat account, which the Snapchat is already in evidence, showing that one. You have Jamell Demons, Jamell.Demons, a Facebook account as well on that. In terms of the content of the messages themselves as well, show that this was Mr. Didens' phone and that he is sending out information and being personal to himself on this. So there are multiple different types of information to show them.
So just to make it, if we were to actually go through all of these, inform the court report, you're going to see messages from both of the deceased, their girlfriends, to other people. There is no question that our client had used his phone, but so did all his friends. So this is a phone that they passed amongst each other. I don't think bringing up the Celebrate or a couple of selfies proves that it was actually his phone. For that argument, there's pictures of Michael Jackson on there. So can I say that Michael Jackson is well owning his phone? Based on her argument, that's what she's saying. I don't think she has given any definitive proof that this was 100% possessed only by Mr. Jamell. Just picture good ideas, I guess he shared the phone with future also.
Anything else?
Yeah.
Dave? No, anything else from the defense?
I would just point out that not only is that phone in Jaden King's name, so is the phone that he's trying to assign to Anthony Williams, which is his name.
I don't, the counsel suggested and gave me sworn phone numbers. One, she, counsel indicated, was Mr. Demon's phone. That's the 713-9807, 772 area code. Then she had, one that was listed as Christopher Thomas' phone, another one as a, Mr. Wither's phone, and another one as, Francois, also known as Track's phone. I haven't seen one as being, Mr. Williams, am I mistaken?
Yes, Your Honor, there was one on Mr. Williams that was on the initial report. That is the 954-248-9081.
954-248.
9081.
That's Mr. Williams, one of the students.
Yes.
It's his phone.
Correct, that phone, and defense counsel is well aware of the fact that the phone that Mr. Williams had at the time of his death was recovered, and a full file system extraction was done from that phone that shows it was his phone on that, and as well as the fact that the celebrated extraction that we just went through also has Mr. Williams saved under the name of Twin in the phone of Mr. Demmons, in which there's discussions back and forth that identified the 954-248-9081 phone number as that of Mr. Williams. And that there's discussions, for example, that they have gone on trips recently. They've gone to Detroit. And there's then again photos of Mr. Williams on the phone of Mr. Demmons in Detroit that are sent back and forth on that.
Regarding this witness, is he going to testify regarding Mr. Williams' phone?
He's going to testify to the locations of that particular cell phone, yes.
They're going to be identified by phone number?
At both.
Anything else?
No.
Please?
Just, if you're going to let it in for demonstrative purposes, I would say at the very least that the names are stricken from the reports and referred, or redacted, sorry. And we refer to only the phone numbers, not to the individuals.
Thank you. So we're going to bring the jury in now. As far as that demonstrative, I'm getting conflicting information. I don't want something going before the jury about this is Mr. Demon's phone or this one's phone. There's circumstantial evidence to that effect, but I'm not putting that in evidence that way. Just show the portion that shows the maps. And you can talk about the maps and the other things, but leave out the portion that has at the bottom or previously bottom or top that identifies Jamell Demon's phone. Just use it by the phone number.
Use it by the phone number. Okay, that's not a problem. So I think I would need just a couple of moments to adjust that.
Go ahead.
Okay.
We're in recess.
Okay.
Let's bring it back in. I didn't do yo-yo, but I didn't say tell not to read. I'm worried about that. Sure. Just bring it back in. Jury's coming in. Jury entering. Ms. Jones, thank you. Please be seated. Unless the record once again reflect the presence of our jury, both the defendant, Mr. Demmons, his counsel, the assistant state attorney, Which remains on the same page, John, and I apologize, but I need to resolve certain issues before we go further. It's approaching 5 o'clock now, so my thought is, when we resolve it, we'll see you all back tomorrow morning. So remember the admonition, do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in your presence, certainly no research about the case, all right? You hear that every time we break, I tell you that, it's very important. So, ladies and gentlemen, I'm sorry for the inconvenience. We'll see you back tomorrow at 9. Thank you. Thank you. Let's reflect the down. Anything further to discuss, council?
I don't believe so.
Mayor, I don't know if I can make the witness aware, especially Vic Collins, because you were on the scene in the middle of your testimony. I can't have any communication with you outside the presence of the defense counsel. If there are any emergencies or anything else, please contact my office, but they get a message to me so that your callings come under that.
Understood.
Thank you.
All right. Thank you all. Appreciate it.
Thank you.
We're adjourned.
Thank you. Danny.